Welcome, everybody. Thank you for joining us for this professional learning opportunity. I am Laura MacDonald, Director of Professional Learning from NCEA. Just a few housekeeping notes as people are joining us. If you have questions during the presentation, feel free to use the question and answer window. Sister Dale will monitor the questions and try to answer them all in the allotted time. Following the webinar, you will receive a link to the recording and an online survey. Once you complete that survey, a certificate of completion for the webinar will be emailed to you. Today's webinar, Serving Students with Disabilities in Catholic School, is being led by Sister Dale McDonald, NCEA Vice President of Public Policy. Before I turn it over to Sister Dale, let's begin everything as we do in prayer. In the name of the Father, the Son, and the Holy Spirit.
Amen.
Amen. Lord, give us new strength so that we can build places of belonging, to create a community for all to share their gifts, to know that each of us is loved, to help us to see the light of Christ in all that we serve. Let us remember that each of us is loved, each of us is willed, and each of us is necessary. May we balance mercy and justice so that we can achieve equity and access for all of your children. We do this in your name. Amen.
Amen.
In the name of the Father, Son, and the Holy Spirit. And now, Sister Dale.
Thank you, Laura, and thank all of you for joining us today as we try to explore how we can better serve students in our schools with disabilities using the IDEA funding that's available to support services for some of our students. I'm sorry, it was not moving. So what I'd like to talk about today is the historical context of IDEA, situating it in the civil rights and special education laws that have preceded it, to look at the difference between 504 and IDEA. They're very often confused and equated, and they're not quite the same, although they serve similar populations. And then we'll look at the concepts in the IDEA law and regulations, and that is 2004. That is correct. That's not a typo. The law was to be reauthorized 6 years after 2004, and there's still no reauthorization. They simply roll it over year after year. We in the private school community have been requesting that Congress take up a reauthorization because we have a number of issues we'd like to raise to make the services for our students more accessible and to be better served. But there's no real interest in reauthorization in Congress at this time, but we will keep pushing it. And then we'll do a little bit about implementation issues and tips for maximizing participation. If you have questions, as Laura said, please type them in the box and I'll try to pay attention as I go. I may let a few run while I'm talking in case we actually cover the topic before we get to the question. So looking at just that we're all on the same page, we're serving students with disabilities. And so we're looking at basically a physical or mental impairment, which limits one or more major life activities, which substantially limits, so that while you're looking here at the physical, physiological, or mental conditions that might apply, the operative word is that limits, so that if a person has one or more of these, particularly kids in our school, one or more of these issues, but is able to attend school, to engage in the learning process, they may not qualify as having a disability. That all comes from various evaluations and recommendations that the school would help provide for determining whether or not it really is a disability. So the historical background of IDEA really is rooted in civil rights law, and we have there three particular pieces of legislation that we need to pay attention to. The Rehabilitation Act of 1973 created the famous or infamous Section 504, and I'll talk a little bit about 504 in a minute. And that is basically a civil rights law that prohibits discrimination in employment and access to federally funded programs and services. And that was later modified in 1990 with the ADA, the Title II of ADA. That's not the Title II we know in other programs. And that expanded 504 to cover state and local governments and private sector entities that operate as public accommodations, whether or not you get any federal money. And so that was the period in which, churches had to put in ramps and access points for people to attend. And churches and schools were considered places of public accommodation. So yes, it does apply to our schools. We have, and on the next slide, I'll talk about some limitations to that application, but basically it applies. And then in 1975, as other civil rights issues were being looked at, people began to push for inclusion of students with disabilities in education. And so the EHA, the Education of the Handicapped Act, later becomes IDEA after it's reauthorized a few times. That expanded public school admission to all students in the least restrictive environment. So that's the point at which, schools that previously had special classrooms where children with disabilities were basically segregated from the rest of the population, had to open up and to include students in the least restrictive environment. So as much as they could be incorporated into the regular program, and that's still applicable today and desirable for the most part. So in the non-discrimination language, the disabilities is controlled by this phrase from the law. This comes from the original 504. No otherwise qualified handicapped person shall solely, by reason of his handicap or her handicap, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal funds. Okay, so we have two things here to pay attention to. The first is no otherwise qualified handicapped person. So whether you're dealing with an employee who is looking, or someone who is looking for employment, either way, a current employee or one looking, or you're looking at students in school or students who are looking for admission, the child or the adult has to be qualified to do what they're seeking to do. So that a person who is looking for admission for their child, and you're running an academic institution, and the child is not mentally capable of accessing the program, of being able to read and write and do what the other kids are expected to, grade by grade, without some help. But if there's a physical limitation, you do not have to accept. And the same physical limitation in the sense that it can be somewhat remediated. So that when we're looking at the admissions process, the handicap alone cannot be why you decide not to take a person or for admissions or for employment. And that's a really important piece that we have to pay attention to. And, no one is required to tell the person or the parent why the child was not accepted. I mean, Harvard does not tell 54,000 kids who were not accepted why they were not accepted. They don't have to do that. But if there is a suspicion that the handicap was the only reason that barred them from employment or entrance, then you are liable to have a civil rights lawsuit on your hands. And the last group that you ever want to get involved with is the Office of Civil Rights at the U.S. Department of Education. They are fearless, they are relentless, and even though you may win the suit in the end, if one is brought by the department or by a parent, you're going to spend a fortune in time and money and nerve trying to deal with the situation. So knowing what's required, what the parameters are before you get into trouble is really key to how to make things work. So for Catholic schools, even though we're not receiving the funds, there's still applicability to a certain extent. So under ADA, the law requires for anyone, including us, that we provide reasonable accommodations that would not cause undue burden, that's financial burden, or fundamentally alter the program. 504 uses the word minor adjustments, but basically we're looking at the same thing. Accommodations and adjustments means that you make some slight tweaks to the program, to the requirements, so that a person can access the curriculum. Modification means you actually changed the requirements so that the student that you may take, who's like a legacy student, all the family went to the school, they want this boy, this girl to come, but the child is intellectually not capable of engaging in the curriculum, but you take the child as a service, you have modified the program. Okay, and that means you have to change. So instead of 4 years of science, they may only have to take one basic science, or so that when they complete, whether it's the eighth grades or the eighth grades or the high school curriculum, they have not done the same work that others have done. So it's important to understand what the parameters are here, because this is where schools, from my experience, have gotten themselves into trouble because accommodations or adjustments are not properly understood by the faculty or the principal. You have to make reasonable, good faith attempts to provide for a student. So a student in a wheelchair can get up the ramp into your school and attend the first 4 grades that are on the first floor. What happens when there's no elevator and 5, 6, 7, 8 are on the second floor? The reasonable accommodation is to bring the 5th grade down to the first floor for that year, and the 4th grade goes upstairs. As I say when I do these talks, Mrs. Smith, who's had that room on the 2nd floor for 30 years, may not think it's reasonable. It is a reasonable accommodation, whether she thinks so or not. So you have to make those kind of adjustments. It's not just putting a child up front or having additional time on task. Those are ordinary things that we see happen, but if the chemistry lab is on the 2nd floor and the child can't get there, the child can still take chemistry using various kinds of technology, so that for things that we used to think 5, 10 years ago were impossible to accommodate, it may take a little more time on the teacher's part. It may take a little more planning among all of the faculty, but it's a reasonable accommodation that we are required to make. So then we'll get to the topic of 504 plans. 504 applies to students in schools receiving federal funds, and the person who writes the 504 plan is the agency that receives the funds. So as private schools that participate in programs, whether they're ESEA and those various programs that we're looking here at IDEA, we're receiving goods and services. We're not receiving money. Therefore, we are not the fiscal agent. So we do not write a 504 plan. Apart from that, and I know some of you may say, well, my district is willing to write the 504 plan. I would be very careful of that, because I think what's important to keep in mind is the school implements the 504 plan, not the person who wrote the district at the district, so that you could get a 504 plan developed at the district that the parent is expecting you to implement, and you don't have the resources to do that. So what happens is that our schools write their own accommodations plan, our own accommodations plan. That is what a 504 is, an accommodations plan. There's some myth out there that there is this magical piece of paper that says 504 and you fill in the blanks. That is not so. There is no federal formal 504. What 504 does in terms of what people conceive as a 504 plan is it spells out what you must do to show that you were making reasonable accommodations for a student. And so whether, the public school calls it a 504, we call it St. Anthony's Accommodations Plan. Generally, these are the components of a 504 plan. And this is what you write as your accommodations plan. It is, if these points here are all followed, that you have an actual diagnosis, that you list the specific accommodations that will be provided and who will provide them. So that, the child may need 4 or 5 things, but the school can only, with its resources and without going into great debt, be able to provide 3 of those things. That's a conversation with the family. If the family can provide the rest, that's fine. If they want to proceed without having all of the accommodations, you get that in the conversation with the parents. And so that you write up what it is that you, the school, will provide, not what anybody else will provide, what you will provide, that you're responsible for. And then you list the name of the person who will make sure the plan is implemented. Generally, it's a homeroom teacher. In elementary schools and high schools, it may wind up through the guidance department. That's something you discuss in the accommodations planning. And so that all of the teachers who deal with this child, who need to know what the accommodations are, receive it, you put it in a school file, you review it annually and make adjustments if needed. So that is modeled after the requirements of 504. As in this case, as well as in the public school, when they're getting a 504 for a child in a public school, there is no money involved. There is no state, federal, local money involved. This is what the school can do with its own resources. So I hope that gives a little clarity to 504. If you follow this plan, the College Board, the SAT, whatever next step you're pursuing, if they accept a 504 from a public school, this is acceptable as well. Another thing, just to make a point here, because I get questions sometimes when I'm doing this as an in-person, ADA and 504 prohibit unnecessary disclosure of disability status to a third party. The operative word there is words unnecessary and third party. So the question comes about, and sometimes principals are dealing with teachers who are, well, he got a half hour more on this test. Why should he get a 90 when this child who finished the test in the prescribed time also got a 90? The purpose of accommodations is to enable the child to access the curriculum in a way that sets him or her up for success. So that if with the additional accommodations, the child can produce what others are expected to produce, that is not disclosed to a third party. So report card is information that the school gives to the parent or guardian of the student. And on that, you can put whatever you want to put. You can put modifications, alternative curriculum, whatever. That is a communication between the school and the parent. It's a protected communication. If the parent wants to waive the report card all over creation and then, discuss it with everyone, that's the parent's initiative, but you can't do that. That's what's really important. You can't do that. So if you use the report card as a transcript, you just send on the report card to the next school the child will be attending, or college, or whatever. It cannot have anything on it that it would indicate any kind of alternative curriculum modifications, accommodations, and so on. So that it's important, if you're using a transcript, the report card as a transcript, it's clear, having no disclosure of the disability, and that the parent agrees to it. because a transcript, an actual, what they call a permanent record card, or at least in my day when I was teaching, a permanent record card, it simply provides information about the student's academic achievement, not about their conduct, not about, some of the other things that we put on report cards. And that transcript cannot again indicate that there's a disability or the student's in a special program if it is, again, an accommodation or an adjustment. And you can't put on there, well, yes, they got this, ranked 12th in class, but he had accommodations. But you can indicate that a student took classes with a modified alternative curriculum. All right, so that when an addition, in the next step, school sees a report card from X school, they expect that this is the curriculum and then this is what the child was able to do. So you can indicate if you have modified and changed the curriculum, but not if the child received accommodations. The same thing you can indicate if a child gets an attendance certificate or alternative diploma of some sort. You can indicate that it is not the regular diploma, but you can say because there is a disability. So I hope that's clear. You never use the word disability on communications. You never indicate obliquely or directly that there is a disability. If the program is modified, then they're not in the regular program. That can be announced, but not why it was. I mean, most people will get it. It's like when you do employment and person asks 4 times, well, can you tell me about so-and-so? And he's like, she was employed here from X to X. Well, what about she was employed here from X to X? Hopefully the person would get it, that you're not allowed to, you're not going to say more than that. So that brings me now to IDEA. So the law that we're working with now is the 2004 law. So when Congress enacts a law, as they did with Public Law 108-446, it says it was enacted in the 108th Congress. We're now in the 118th. As Bill 446. They put out these tomes. Sometimes they're an inch thick, sometimes they're a half-inch thick, very tiny print that specifies everything in the law. They're usually so complicated and convoluted, and then the Department of Education puts out regulations, and that helps you to understand what the law is talking about. So for IDEA legislation, the regulations are in that deal with parentally placed our kids in private schools. That's parts 300 to 301. And they were published in the Federal Register in 2006. It takes them a while to get things out. And then that isn't satisfactory for most people. There's, well, what about? And so then the department puts out guidance. And several times the department has issued guidance dealing with our children based on things that are reported to them, questions that are asked. What's really important to keep in mind is that when these laws are passed and the regulations, the U.S. Department of Education sends notice to the state education agency, whatever you call the highest authority for public education in your state. And then they're supposed to send that to the district so that the person who you're dealing with in the district over various programs should have received the law, the regulations, and the guidance from their state education office. You're lucky if they get one or at least one of those documents. So it's important that you or whoever negotiates the programs for your schools understands what particularly the regulations and the guidance are. All of those documents that pertain to private school students being served are on our NCEA website. And so, I recommend that you download them, whoever is dealing with these issues with us, with the LEA, the public school district, that they have copies of it, that they read it before they go, and that they share it with the person there. Because frequently the person they're dealing with has never heard of what's contained in these documents. So as I said, in 1975, the Education of the Handicapped Act was first authorized and has been reauthorized several times. The key pieces that came out of that in terms of placing children in an educational environment who were previously excluded or restricted is free, appropriate public education. So as a civil right, every child is entitled to a free, appropriate public education in the least restrictive environment, so that they're not just warehoused in one group, but that they are able, as far as possible, to interact with their peers, and that those children receive an individualized education program that lists what their disabilities require in order for them to be able to participate. So after 1990, it was called IDEA. It's what we're still looking at now. As I said, we had a reauthorization in 1997, and then we had one in 2004. I was around working on this for 97 and 2004, and we were able, given the experience that we've had dealing with people out in the field, of the problems they encountered in trying to implement IDEA, to get some implementation changes in the law that have made it a little easier. Certainly, we want another reauthorization because we have another whole list of things that we think could be changed. So the concepts in the law, these are basically the pieces I'll talk about going forward. So I will just read all that at you. So FAPE is an education provided at public expense under public supervision and direction without any charge, and in conformity with the IEA program that's the IEP program that's developed for each child. We had a couple of lawsuits going back in the late 1990s about what does it mean, public education. And while a couple of cases were making their way through the Supreme Court in the hope that we would get a favorable ruling that every child, regardless of where they go to school, is entitled to education services, Congress at that time, and then the OSEP, the Office of Special Education Programs, interpreted that to mean public school control, so that our children who are in schools with special needs are not afforded FAPE. You have to go to a public school building in order to achieve FAPE, or the parent has to place you there. What we find is that we're dealing now with what we call parentally placed students. So parents who choose a non-public school where their children are not entitled to FAPE. That's the current law. But students who public authorities, so if you have a student in an LEA that requires very specialized services for, say, deaf or blindness, and the district decides it would be, hopefully the first thing is better for the student, but certainly less expensive for the district, to send the child to X school for the blind and pay the tuition there, rather than have to hire teachers and specialists and so on in the school. So if the district decides to place you in a private school, you are still considered receiving FAPE. And all of that is paid for by the public authorities. And so we have been trying for years to say, wait a minute, a civil right is a civil right. If the parent chooses one option, they lose a civil right. But if the district decides to choose the same option that the parent was denied, then because the district chose it, then the student gets FAPE. And so it's basically a fundamental injustice here to students, that it's not where you go to school, but who decides where you go to school, which certainly we see now in many states, apart from this issue, moving toward greater parental choice in education and being supported in that choice financially. So if you are a parentally placed student, and that means you're going to a private school because your parents want you there, whether the parents are paying full tuition, whether the school is giving some benefit, or if you're on one of these state scholarship programs, vouchers, or whatever they call it, you are still a parentally placed student. Okay, so because you get a state voucher for special needs or for whatever, once the parent chooses to use that voucher for you in a private school, you are still a parentally placed student, not entitled to FAPE. And according to the law, parentally placed students are to be provided the opportunity for participation. Opportunity. Every child must be considered who has a diagnosed disability, but only some get served. I'll talk about that a little more. But any child who is diagnosed as having a disability in that district is counted as a student with a disability, whether they're served or not. And the number of children who are counted, anyone with a diagnosed disability, not just those served, but anyone that the district recognizes as having a diagnosed disability, is counted in how the money to serve private school students is generated. So every student with a disability generates some funding, but they don't get to spend it. All right, that's another big issue that we need to look at, so that private school children are generating money. The money goes into a large pot for all the private school students in that district. And then through a negotiation process, some kids are given services with that money. In trying to determine who gets the services and how the money is appropriated and so is apportioned, the law requires timely and meaningful consultation between the private school representatives and the representatives of the district. And at those meetings, there's supposed to be a parent or two that represents all parents. And the law says the consultation happens during the design of the program, the development of the program, the implementation of the program. Very frequently, this does not happen in that order. But this is what the law requires and what you as a private school official have the right to complain about. And complain is used in a formal term here, if they're not doing what they're supposed to be doing on the district level. So that the district must involve a private school official in what happens in terms of the programs being developed and the services provided. And so when you go to the consultation meetings, and there's an S at the end of that, it's not one meeting. One meeting does not a consultation make. This is an ongoing process where you discuss, how we're going to develop the equitable participation rules. So how are we going to consider these children? How will parents going to know what's possible? How will they be informed about being evaluated and being considered? So that the consultation process goes on throughout the year. A big piece that needs, discussion is the types of services, direct services or alternative service delivery mechanisms. That's important because all options are to be considered that you wish to raise. So that's whether you have certain children that you want to get one-on-one services, or you have a couple of teachers who could benefit from professional development in a couple of areas that could serve more students, whether you want the public school district to deliver the services, or you want a third-party provider, one of these companies that does these kind of service programs. You also have to talk about the actual dollar amount. The district is required to tell you how much money they got for IDEA from the federal government, from the state to the feds, how much how many public school students that includes, how many private school students that includes. The ratio of public to private is what determines the proportionate share for the students in your schools. There is a process that was developed for the last program reauthorization that requires a written affirmation, so that when the process is done, and that's after a couple of meetings generally, the district will ask you to sign an affirmation of consultation. So basically what you're signing is, we went through this process, they did all the required topics on the last couple of slides, and we feel that they have reasonably dealt with us in terms of how we're going to serve our students. If that didn't happen, if you went to one meeting, they passed out a piece of paper and said, sign this, it's consultation. It's not. And I tell people, don't sign it. It's an attendance sheet. It's not consultation. And so refuse to sign it, and then send the district and send the state education agency a letter, generally certified letter, so you have proof that the district did not do this, and this, whatever they're required to do. And as a result, your children are not being treated fairly. So the big clue to all of this is, how do we navigate the child find process? Child find is basically the code word for how do you evaluate the children. It is the responsibility of the LEA in which your school is located. And that was a change in the 2004. It used to be the home district. Now it's a school, it's the district where your school is located is responsible to locate the children, to evaluate them, and to serve them if they qualify. The child find process has to ensure equitable participation. And what we've learned over the years is that it has now, the law and right, it has to be done at the same time the public school evaluations are done. It's not, we'll get to you February, March when we're finished our own. They have a 30-day window in which to evaluate whoever is referred. And they cannot limit the evaluation to a particular disability. Well, we're only screening for hearing this year. We're only screening for speech. We're only screening for learning disabilities. They're not allowed to do that. They have to screen for the disabilities that are suspected. And I'm sorry, whoops, I spoke quickly before, that you have a 60-day window for the evaluation. It's 30 days for follow-up when you're complaining. So that's an important piece, so that if they keep delaying the evaluation, then you have a right to complain to the state education agency that they are not fulfilling, and that's in the law. That's not just regulations. They can't tell you that there's no money left over. Well, we don't have any money now. We did too many evaluations. The evaluation of the child, whatever that costs, does not come from the proportionate share. So that when we're looking, as I said, the ratio. So if private school students in the whole district, from whatever school is private, if they are 7% of the district population, then 7% of that money is what goes for equitable services. The district then spends the other 93, how they want, but they also have an administrative budget. And from that administrative budget, they have to do the evaluation. So they can't tell you there's no money for an evaluation. They can tell you, well, go get a private one and we'll see if we accept it. No, they have to comply with the law, or you file a formal complaint. Some parents do want to go and get a private evaluation, but it's up to the district to decide whether or not they accept it. They're not required to accept it. What's important for most of our students who will never receive any services because the money runs out before all can be accommodated, is to get the best evaluation possible. Because frequently, if the district thinks that, you're going to stay in the school anyway, you get a very different evaluation from that which the parent goes in and says, my child is having difficulty. We want the child evaluated. We want to see whether or not we will accept FAPE, meaning we'll transfer our kid to a public school. It's no guarantee you're going to do it, but the evaluation that's provided and conducted is a much more comprehensive evaluation than if they just kind of blow you off and say, well, they're staying where they are anyway. So that if that's the only thing you're going to get from the district, which is the evaluation, you want the best, most comprehensive one you can get, because then you deal with the parents over how you're going to accommodate if you're not going to get services. And it's a difficult dance to do with the parent. You don't want the parent worried that, you're going to like put my kid out. But that, explain to them that there will be, a much more thorough evaluation. So the proportionate share, I sort of referenced that as I was going through, that the ratio of public to private schools determines the money in the pool. And from that pool, those who are selected to receive services are served, so that, again, you have no individual entitlement to be served if you're parentally placed. If you're parentally placed, your entitlement stops at the evaluation. Every year, the LEA has to conduct a count of children with a diagnosed disability. And so that's part of the consultation. What day are we going to collect this? So they do it district-wide, anywhere between October 1 and December 1. And so the count that they get that December or somewhere in there determines how much money will be apportioned for the next year. So it's important that every child with a disability is counted, not just the ones who are being served. And frequently we forget if the child with a disability is not being served with IDEA or even with accommodations, but still has a disability, they're counted. And so each child counted raises the total amount of money in the pool. So when you're referring a child for evaluation, this is where, we've had trouble over the years. The child must have one or more of the above and need special services. And so you separate out, and that's important when we're looking here at most of these have some kind of physical impairment. But if we're dealing with learning disabilities, potential learning disability, then we're looking at really, fluency in being able to read and write, and once you're provided with appropriate experiences. And a lot of this got refined in the last law because so many children from across the spectrum, the whole gamut of children suspected of having a disability, frequently, they put in kids who were just discipline problems. So you have to really do a little bit of pre-evaluation that, the child is not doing well. You try to figure it out. What's the problem? How have you tried to do some strategies to see if that can be improved? The important thing is that, you give a test and, 90% of the kids fail the test. Well, probably it wasn't the kid's fault. There may have been something in the teaching process. And so then you reteach it, and then, like maybe 5% fail, and you work with those 5 and another 2 just still can't get it. They may have a learning disability, those 2. Program that was developed as part of this last reauthorization was what they call the RTI, the Response to Intervention Requirements. And many public schools went through elaborate developments of RTI programs and so on. The last bullet point on here is, if this is all you remember, that's what's most important. The LEA may not require our schools to use the LEA RTI process. You have to simply document in some way that there's a problem. You've tried a couple of things, that it is probably a learning disability, not a teaching problem. So if a child receives FAPE, they get an IEP, that's in the law. And so some lawyer came up with this description for, well, if you're not entitled to FAPE, but you're going to get some services, we can't call it an IEP because that says you're entitled to FAPE. How they made that up, I don't know, but that's basically the issue. So for children who are parentally placed, you get a services plan. And the services plan only describes what you will be provided. An IEP gives the full range. These are your 6 issues. This is what needs to be done. Your evaluation says in a parentally placed child, these are the 6 issues. This is what the service plan says. This is the one thing we'll deal with. We'll deal with speech, and this is what's going to happen. A private school person is supposed to be there with the parent. The important thing is due process rights for parents do not apply. In public schools, they're suing left and right all the time. They didn't get the right prescription of services. They don't like the services. Unfortunately, our parents can only complain about and appeal refusal to evaluate. So the services plan basically describes exactly what they're going to do with the IDEA money to serve your student. It's important that the services plan, the SP that's written by the district, only has in it what the district will do. What you're doing in terms of accommodations or whatever else you're dealing with the parent, do not mix the 2 documents because you don't want to be on the hook for what the services plan is supposed to do. And so don't mix and match. If they say, well, what will you do? You simply say, we'll deal with the services plan here. We'll deal with what we're doing back home in the school. The IEP, that last one is important. The IEP that the child has from a public school, if they transfer to our schools, doesn't come with the child, right? It stays with the public school. The IEP only applies to kids who have FAPE. So that in moving to our school, you go in through either SPs if they're going to do that, or accommodation. So it's important you let parents know that when they're trying to transfer from a public school to one of our schools, that the IEP doesn't come with them and that you may not be able to provide everything that they were getting on the IEP. So just a quick, comparison side by side that, the 504 is developed with teachers and parents. It says what's going to happen in your regular classroom, and the regular classroom teachers monitor it. Whereas SP has a whole team, differentiated educational services, usually not in the regular classroom, and specialized staff that are provided either by the public school district or a third party. But there is no money in 504. There is money in IDEA to provide the services. Transportation, this is a key piece. We tried very hard in the last go round and to get the accommodation, to get the requirement that students be served in their own school. But because of a lot of legal stuff, particularly, for public school students who have to go out for certain services, they couldn't mandate that it has to be in the school. But they highly recommend it, and they have recommended it again in the latest regulations. Because if the district is going to serve your students, but they had to go to some other public school or some public site, the money to transport them comes from the services money. So that if a child is going out for 20 minutes worth of speech, you've got to provide a van to take them, a driver, a monitor chaperone, and then transport them 15, 20 minutes to a site, get services, wait for the bus, come back. You're paying for all of that in addition to taking the kid out of regular instruction, so that it makes no sense. Pedagogically, it's inappropriate, and we're still trying to get that for a lot of schools. But depending on how the state interprets its plain amendments, it doesn't always happen. And then just evaluations. The term evaluation is used in 2 contexts. One is child find, trying to get the child evaluated to determine eligibility. And then the reevaluation at least every 3 years. Is this child still considered one with a disability? And then Again, all children are supposed to be reevaluated rather, after 3 years, whether or not they're receiving services. And then the other evaluation is the student performance. Well, they're getting these services. What's the result? Are they improving the student's ability? So if there's disagreement over the provision of services, the LEA must deal in the consultation process with the requests by the private school. And if they refuse to do that, what you request, I want a third-party provider, they have to provide you the reason why not in writing. And depending on whether it's realistic or, just like, we don't want to do it, you have grounds for appeal. Again, they have to consult with you, but the district has to consult with you, but they have the final say. And then unfortunately for parents, all they have due process for is whether or not child find, whether, if they don't like the services, the quality of the services, they can't appeal that as a public school could. So, the private school can complain that the LEA hasn't done what they're supposed to do in the consultation process. And it's important that when you're complaining, when you're filing a formal complaint, that you specify what was in the consultation requirements or the law and regulations that they did not do. Whether or not, the person is a gruff personality, whatever, that's not a grounds for appeal, right? You can only appeal on the basis of this is the law and regulations, and they didn't do it. So I think it's important when we're going through this, that you understand the difference, and the difference if you're in a state that has state laws that provide some services, not many do, but, to make sure the state is separated from the federal, that IDEA is separated from 504, so that you're not confusing and conflating programs, because each of them operates under a different rubric. Make sure, as I said earlier, that who's ever doing the consultation has copies in their hand of what it is that you need to be able to insist that the district do, and not have them say to you, no, that's not allowed. And you say, yes, it is. And you go in with, the appropriate documentation. It's also important, that the person negotiating has whatever is required on the timeline that is proposed, so that you have the number of kids, you have whatever paperwork you need for the evaluation. And then I think the most important piece is that you focus on the needs of the students and not the convenience of the school or district, which sometimes trumps everything else. It's a child. We want to serve these children. We want to get the most help we can, because we can't do it all on our own. And so it may be a bit inconvenient for you. It may be a bit inconvenient for the district person, but that's not an issue. Serving the student is what's at issue. So I'm going to start now on the questions. There's my contact information. I'm always happy to answer email or take phone calls. I do return in a pretty reasonable time, usually that day or the next day. Okay, so we start up here where Oakland wants the school to dual enroll in the public schools. Yes, that is not a requirement anywhere in the law. They do not have to enroll if they want to access FAPE, and I'm not sure what the requirement is there. So if they want to be dually enrolled, they may get services under FAPE, but I would need a little more detail there. But the answer is no. You're not required to dual enroll. About a blind student. Again, whether the district will serve the student or not depends on how they see their pool of money. And generally what they do is they say they have, $200,000 to serve, 13 schools in the district, some Catholic, Jewish, private, whatever. And then they actually could spend the whole $250,000 on one kid or 5 kids, Or they could look at it and say, how much can we get from all of this? So maybe they're going to do speech, maybe they're going to train teachers to understand how to do instruction for learning, specific learning disabilities. This is where, you engage in the consultation process, but that's something you have to negotiate also, with the parent. If you're doing accommodations, they're not getting IDEA services, and what can we do? Right. So, yeah, so we don't want the Oakland or any public school district to write a 504 plan for our students, because we will be obligated to implement what they write. And that's why I said earlier, we're not getting the money. We don't write the services. We don't write or accept from them a 504. We write our own accommodations plan. No, the plan, the person asking about, graduating 8th grade, or they're going to another school, do we send all the accommodations? No. The parent then has to notify the school. If the parent wants you to, yes, you could. You never, on a modified transcript, the program was modified, you can simply make a notation on that. It can be an asterisk, it can be a sentence. Parents, consultation, when do you reach for consultation? Whenever the parent feels that they're ready to ask for the consultation. So you speak with the parent formally, but you work with the parent, and the district has to respond. They can't say, when the request for an evaluation is made, they have 60 days in which to complete the evaluation, whether it's public or private school. They don't have to wait to go through process. So, it's important if they're doing the count, somewhere between October 1 and December 1, you want to get in that count, because that's the count for the next school year's money. Right. No. SPs are only used for parentally placed students who are going to be served. So if they're, in the pool that's considered, and they've got a speech problem, but the district is going to spend the money more on students with learning disabilities or occupational therapy, then the student's not going to get any services. And say they don't get, if they don't get SP, they get nothing. The SP only says what they're going to do. I think I said that earlier. If you're diagnosed with like 5 things and you're going to get services from IDEA money, but only for item 2, not, the rest of them, then the SP only deals with what you're going to get, so that the other disabilities are not considered on the SP. If they were in a public school with FAPE, they get everything on an IEP. Okay, this one I have to, as most private schools access some sort of federal funding, they should not be accessing federal funding. You're accessing equitable services, goods and services, so that you are not required to do a 504. Any accommodations plan that you write following the rubric of what they do on a 504 in a public school, that is an acceptable document for any further consideration. No, okay, this one, Andrew Cooper. Yes, you have to have a diagnosed disability in order to be counted and to receive services. They cannot tell the parent to get an evaluation. That's the one obligation the district has regarding our students, which is to evaluate those who are presented. They should not go for a private evaluation. They can't have them. So if that is what happens, immediately complain to the state education. They're refusing an evaluation and want us to get a private. That is not what the law allows. The lunch program there's a lot of complications with the lunch program about whether it's goods and services or it's actual federal funding. That is something that you need not, I don't conflate it with IDEA. Proceed as if you are not receiving the federal funding. Nope. Okay, Catherine Shea and the RTI process. If you send me an email, my information's mcmcdonald@ncea.org. I can send you a copy of the letter from the state, from the federal government to the SEAs that says you can't do that. No, and the same thing with the only, please go on, all of you, go on the NCEA website and download the updated guidance that has the Q&As, and that those questions are answered there. No, the LEA does not have to provide the services. You can work with the LEA and have them hire a third-party contractor so that the funds then go to, you know, one of these companies, you know, Fax, Catapult, there's a bunch of them that do those kinds of services. No, behavior plans do not go on to any, you transfer to the next level of education or other school, the academic achievement. Does the annual count? Nope. No, well, the annual count only includes students that the district accepts as having a diagnosed disability. So if they accept a private evaluation, yes, then they're counted. But if they insist on it being a evaluation they conduct, then the private doesn't count. Yes, the district ultimately decides, and that's part of the consultation process on how the services are provided, who gets to spend the money, basically. And so that's part of consultation. And if they don't give you an opportunity to express your desires and don't tell you in writing why they don't want to do it, you have grounds for complaint. Title funding is not federal funding. Title programs are goods and services. It says right in the ESEA that it is not federal funding. And it's also, if you look at the download the guidance documents, you cannot claim they need more RTI. That's, again, it's in the guidance. No, dealing with family looking to have an aid worker. That's something that was something you would be dealing with in the accommodations that you're dealing with the family, and that's up to the school and to look at the whole parameters of what that involves, whether or not you're able to accommodate that. How it has nothing to do with least restrictive environment. That's just an additional aid. For county students, you may, if it's a private evaluation and the district accepts it, you count the kids. If not, yes, the services plan that the district writes would be a plan, would be a legal document. They're writing that in accord with the principles of IDEA. So I see we're 5 minutes over. I'm sorry. And there's one in the chat. Let me see if I can get that. Oh, Laura put in there my email address. So I thank you all for attending. You have my contact information. I'm happy to follow up with you. We're all in this together. We want to be as welcoming as we can with the resources we have to serve the children who probably need us most. So blessings on your continued work with your students. And if I can be of help, let me know. So thank you very much.
Thank you, Sister Dale. Sister Dale will be presenting at this year's convention in April, Government Programs, Advantages and Pitfalls, if you're interested. Also, you will receive a link after this session Once you complete the survey, a certificate of completion for the webinar will be emailed to you. Thank you so much. Have a good day.
Thank you, everyone. Thanks, Laura.
Thank you.
Okay.